Once again, the Canadian Privacy Commissioner was in the news looking for order-making powers and the ability to levy penalties. I have some concerns with this, how this affects due process, and how these concerns can be addressed. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you my opinions on the topic, and these opinions should not be attributed to my firm or any of its clients. This past week, the Privacy Commissioner of Canada, along with some provincial counterparts, issued a report of findings related to the Tim Hortons mobile app and location privacy. He used the opportunity to again call for order-making powers and the ability to levy fines. He reiterated that at his final appearance before the House of Commons Standing Committee on Access to Information, Privacy and Ethics on June 2, 2022. He said that he needed the power to issue orders and to impose significant monetary penalties, and noted that the Tim Hortons matter was evidence of the need for these powers. I don't think he's fully made the case for this, and has not really used all of the remedial tools already in his toolbox. I also think we need to be careful about this and ask ourselves whether the evidence is there, and whether the current model is actually broken. And if we're going to have orders, fines, and penalties under Canadian privacy law, how could we do this in a way that is consistent with the fundamental values of our legal system? Canada's Personal Information Protection and Electronic Documents Act has been in effect since 2001. Some may assume that it's inherently outdated because it's been around for more than 20 years, and during that time we've entered the age of social media, online streaming, mobile apps, etc. I suggest we take a closer look at that. The current law is based on a particular model, where the Commissioner is an ombudsman whose job it is to solve problems, and it's up to the courts to issue orders and order compensation. Anyone can complain to the Commissioner, and the Commissioner has to investigate. The Commissioner can also investigate on his own initiative where he has reasonable grounds to do so. He can also fully audit an organization if he believes the organization has contravened PIPEDA, but to my knowledge, his office has never done so. In the course of an investigation, the Commissioner has very strong powers and can enter any premises other than a dwelling without a warrant. He can require the production of records. He can compel testimony under oath and can accept any evidence that would otherwise be inadmissible in a court of law. He has more powers than the police. In practice, the Commissioner's investigators reach out to the organization, find out their side of the matter, look into it further, ask questions, ask for records, and try to find a resolution that's satisfactory to the complainant and to the Commissioner. In most cases, the Commissioner does not have to use his coercive investigation powers because organizations generally cooperate and are looking to have the matter resolved. The end result of the investigation is a report of findings, which is generally a resolution that is mutually satisfactory to the Commissioner and the other parties. According to the OPC's annual reports, a matter is not resolved until the Commissioner is satisfied with what the organization is now doing. If we look at the breakdown of the cases published on the Commissioner's website, the largest portion are settled. Only 14 out of 126 cases that reached a conclusion on their merits were not, quote, resolved, unquote. This means that only 11% were not resolved to the full satisfaction of everyone concerned, including the Commissioner. If it's well-founded and resolved, the organization may have been in violation of the statute, but the issue was addressed and fixed to the OPC's satisfaction. This means that 89% of the cases that make it as far as a full investigation are resolved to the Commissioner's satisfaction. But what about the 11% where the Commissioner has found a violation that wasn't resolved to his satisfaction? Well, PIPEDA has a solution to that, and it's one that the OPC has hardly used. To me, it's a bit problematic for the Commissioner to say that he needs more powers when he hasn't fully used the powers that he has been given. If the Commissioner is not satisfied at the conclusion of an investigation, the next step is an application to the federal court for an expedited hearing. At the court, the judge will review all the evidence from all the parties and make a conclusion as to whether PIPEDA has been violated. The Commissioner is not the final word on this, and the courts have consistently said that his conclusions about whether an organization has violated PIPEDA are not to be given any deference. The Commissioner very seldom takes this route, though, but when he does, the vast majority of them are ultimately settled before going to a hearing. You don't settle a case unless you're satisfied with the conclusion. So settled cases mean that the matter was resolved to the commissioner's satisfaction. I can only think of 2 cases that were not discontinued on consent. Now, if we circle back to the Tim Hortons case, the commissioner started an investigation on his own accord after reporting by James McLeod came to his attention. The commissioner, along with a number of provincial counterparts, investigated and issued a report of findings in which they concluded the company had violated PIPEDA and provincial privacy laws. But at the end of the day, the company had addressed them to their satisfaction. Problem found, problem addressed, and problem fixed. The law worked as it was designed to. The only real question is whether they should be punished for it, and what should that look like. And I think we're seeing a more general thirst for blood among commissioners and privacy advocates. As a result, I think that fines and orders are now inevitable, and we're going to see them in the anticipated replacement for PIPEDA. Now, I have some thoughts on how this should be done. I've been paying pretty close attention to the actions of that office since PIPEDA came into effect in 2001. I've been involved in many investigations by the Privacy Commissioner. Under the current scheme, an investigation is surprisingly cooperative. Where it is clear that the Commissioner is seeking a resolution, and hopefully a fully negotiated one, the parties are focused on the solution and not on accusations and defensiveness. That will change completely once an investigation turns from a problem-solving exercise into one where the Commissioner is looking for ammunition to publicly punish the organization. This whole process will be turned on its head. This, in my view, would be very problematic. The issue is that if you give the investigator and the prosecutor the power to impose punishments, you're implicating some pretty important principles of natural justice. It gets a bit worse when the police and prosecutor are also given an educational and advocacy role, and then throw onto that the ability to issue guidance on what they think the law says and means. In our criminal justice system, you have the police who investigate crimes and the prosecutors who prosecute the offenders. But at the end of the day, there's a hearing in front of an impartial judge. In the current system, the Privacy Commissioner investigates, tries to resolve the matter, but it can be sent up to an impartial judge to have the final say on whether the organization actually violated the law and should they be ordered to change their practices. The model espoused by the Privacy Commissioner would dispense with this important structural protection that, in my view, is essential for fairness. He would get to be the cop, and sometimes even the complainant, the prosecutor, the judge, the jury, and the executioner. And maybe you'd have a right to appeal to a judge, but the Commissioner's findings would be presumptively true. And we've seen in the past that the Commissioner has been wrong in interpreting his own statute. We've also seen the Commissioner try to shoehorn concepts like the right to be forgotten into the existing statute. Currently, when matters get in front of a judge, the courts don't give him any deference. That's the way it should be, in my view. If we're going to have fines and orders, they should be issued by impartial judges who look at the facts, look at the law, and come to an unbiased conclusion. Now, there's a middle ground that I can largely agree with, though, with some caveats. In 2020, the government tabled something called the Digital Charter Implementation Act, which would have created a Consumer Privacy Protection Act and the Personal Information and Data Protection Tribunal Act. It did anticipate fines for organizations and orders too, but it did so in an interesting way. It proposed fines and orders, but it was up to an independent tribunal, the Personal Information and Data Protection Tribunal, to actually impose the fines. The Commissioner can still be the cop and the prosecutor, but it would be up to this independent tribunal to impose them. On one hand, you could avoid setting up a whole new commission in Ottawa by sending it to the federal court, like we do now, but I can appreciate the desire to have a tribunal with expertise on privacy. In my view, this sort of structure should supply the appropriate division of powers, so to speak, to protect procedural fairness and unbiased decision-making. I much prefer it to the structure of Canada's anti-spam law, in which investigators are the ones to levy penalties, and the appropriateness or the amount of the penalty can be appealed to the CRTC. Giving the investigator the ability to set the penalty and impose it has the same problems as giving that power to the Privacy Commissioner. With CASL, having both of these within one structure or institution doesn't have enough separation in my view. What was proposed in the Consumer Privacy Protection Act was not ideal, however. The Commissioner's decision would still be the basis of the tribunal's decision-making. It would be much preferred if the Commissioner had the role of the prosecutor and had the burden of making its case to the tribunal. This also doesn't address the other issue about the currently collaborative nature of investigations with the OPC. Now both organizations and the Commissioner look to do their best so that the matter is resolved. If the Commissioner's objective is to recommend a huge penalty, that becomes massively adversarial, and the previous cooperation goes completely out the window. Organizations will become more defensive than they are today. This may be okay with the Commissioner, but I don't see that as an improvement. It has been said that the new long-promised privacy bill will be tabled imminently. It will be interesting to see what has changed since it was tabled in the form of C11 before the last election. As I understand, a large number of organizations and groups have been looking to have it significantly tweaked. I expect it will include penalties and order-making powers, but I really hope that they remain in a separate body to protect the overall fairness of the legislative scheme. I hope this has been of interest. When the new bill drops, you can be sure that I'll have some thoughts about it. If you have any questions or comments about this topic, please feel free to leave them below. I read all the comments and reply to them all as well. Also, if you have any topics you'd like to see covered in a future video, let me know that too. If you'd like to see more videos like this, please hit like and subscribe so they'll show up in your feed. And of course, feel free to share this with anybody for whom it may be useful. Thanks so much for tuning in.